count on it. This is NBC10 at Issue.
While there is plenty of debate over what the Trump administration is doing when it comes to funding and policy and immigration, a recent political firestorm has centered around documents connected to the investigation into Jeffrey Epstein. He died in prison in 2019 while awaiting trial on sex trafficking charges. His death was ruled a suicide. Well, the Trump administration is pushing back on a Wall Street Journal report this past week that says President Trump is named multiple times in the unreleased Jeffrey Epstein files. The paper, citing senior administration officials, also notes that Attorney General Pam Bondi told the president in May that his name appears multiple times, along with other high-profile figures. Now, a DOJ official tells NBC News that a mention of anyone's name would not necessarily suggest wrongdoing. The Attorney General said nothing in the files warranted further investigation or prosecution. On Wednesday, a federal judge in Florida rejected the Justice Department's request to have secret grand jury transcripts unsealed from the Epstein investigation. The House Oversight Committee also plans to subpoena Epstein associate Ghislaine Maxwell. Maxwell is serving 20 years in prison for recruiting and grooming teenage girls for Epstein to sexually abuse. And joining us now to discuss all of this further is NBC10 legal analyst Enrique Latoison. Welcome. Great to see you.
Nice to see you.
Help us to break this down and understand this, because the request was made by the DOJ to release these grand jury transcripts. It has hit a roadblock. Why is that?
So grand jury is different from the Epstein files. So the word Epstein files is being used to basically say everything involving the Epstein case. It's very important to understand that the grand jury testimony is a separate thing. The investigative file is a separate thing. And when you put the two together, the word Epstein files is what's being said about all of these things. But there are different rules and different laws depending on what we're talking about. So if you're talking about the grand jury testimony, there are laws involving grand jury transcripts. It's a secret proceeding that's done, a very important proceeding that's done in the justice system, allow prosecutors to be able to convene a grand jury of people to be able to listen to the evidence that they're presenting. It's not cross-examined. There's no defense attorneys or anyone in there. And they basically put all this information out there, and the grand jury listens to it and says whether or not there's evidence to possibly file charges. So this is something that's done before charges are even filed. So because that proceeding is such a sacred proceeding here in the United States in our justice system, it is very basically impossible to have those types of proceedings opened up for the public to be able to look at it.
If these grand jury transcripts were to be released, would you expect that we would see attorneys starting to ask for other cases to also be released? Is that one of the concerns?
Absolutely. And also, too, usually the grand jury testimony isn't going to be, quote, the most juiciest information, because it's basically a prosecutor just basically giving some evidence of things that they believe is going to be favorable to them in order to just get to the probable cause. It's just talking about probable cause here in order to file an indictment, in order to file charges against a defendant. So basically, it's kind of a smorgasbord of different things that they throw out there in a grand jury.
Does it include like supporting documents? Would grand jury materials include like the supporting documents as evidence?
It could, but it only needs to be just enough for the prosecution, very low bar for them to be able to get a grand jury to agree to find them in favor to go ahead and file charges. So in order to, you're going to open up this grand jury testimony. People are testifying in secret. They're being told it's going to be in secret. They're told it's confidential. We're talking about people who believe that they're talking about things that will never be revealed to the public. That is one of the core points of a grand jury testimony. So it is pretty, I'm not surprised that the grand jury testimony is not being open. But once again, that's only part of the Epstein files. I mean, the whole other part of the Epstein files is not the grand jury, and this is something that could be released. So
there are parts that you think that the DOJ may have that they could just put out that wouldn't include grand jury testimony. But that wouldn't be everything then.
Well, then this is where it gets interesting. So when you look at, quote, the Epstein files, this is their investigative file. This is everything that they used, or all the notes and different things that the different FBI and different individuals took from interviewing witnesses and things of that nature, all the things they uncovered. And based on what they had in the Epstein files, they used what they had what they believed at the time to have enough evidence to prosecute.
So to your point from before, those files could still contain things that were not the basis for charges, things that there still could be innocent people or victims.
So this is kind of what the issue here. They might have heard from, they might have, for example, they could talk to 100 witnesses, and witnesses could tell them all kinds of things. They write all these things down. Doesn't mean that things are true, but they're in the Epstein files.
They're part of the investigation.
Right.
What's the standard when an investigation like this is done? Is everything kept? Is that the standard, that you keep everything for a certain amount of time or forever?
Well, people appeal. People appeal to a higher court. New evidence is discovered. So, yes, when you have a file, as soon as you obtain a conviction, or in this particular case, a suicide, a person died, they don't just throw everything out. I mean, that stuff is still there. I mean, the Justice Department, if they wanted to, could release these files. However, anyone's name that's in that file automatically is going to be assumed to have been doing something wrong or something illegal. And in the end, they only file charges against 2 people. And one of them obviously isn't here now. So I think the whole thing is, how do you release those Epstein files, those investigative files, without tainting innocent people? Or how do you do it in a way where you are basically saying maybe this person did something wrong, or a roster or a client list? There could be a client list. There could be people on there who did bad things. There could be people on there who did nothing wrong. So then you get into the slippery slope of, if you're going to release those investigative files, how are you doing it? Then are you redacting this? As soon as you redact something and put a black line, people are going to say, well, what's in the black line? What are you covering up? So it's actually, it's just a mess. It's an absolute mess of how do you help quell the public's interest in conspiracy theories, but how do you release information where maybe you're getting the bad people, but then protecting the good people, and then who decides who's the bad, who's the good? It's just a mess.
All right. Well, thanks for being here to help us wade through it all. We'll wrap it up there. NBC10 legal analyst Enrique Latoison, thanks for sharing your expertise. Just ahead, a peek at my battleground politics conversation with the Democratic